of In the Abstract, the Lakeland Title podcast. I'm your host, Bryan Jeansonne, the founder and owner of Lakeland Title. For this episode, we're going to answer the question, can you get out of a real estate contract? Now, first, some caveats. We're only going to go over the state-mandated Louisiana residential purchase agreement. So that's the purchase agreement that is mandated to be used for any residential purchases in Louisiana. So if you're buying or selling a commercial property, you would use your own contract that either your attorney or your commercial realtor would come up with. So it's going to have different provisions than the one that I'm going over. Also, this should not be construed as legal advice. So you should always consult your own attorney if you're going to try to break a real estate contract, because it is a serious obligation. And so you don't want to do anything that could get you in trouble. So don't just listen to me, some guy on YouTube. Consult your attorney in your jurisdiction to make sure that you're doing everything the proper way. So with that, we'll get into the Louisiana purchase agreement. So other states probably have similar state mandated purchase agreements. The one in Louisiana is formulated by the Louisiana Real Estate Commission. So your state's real estate commission might have something similar that you could go look at and read through. So in the Louisiana contract, once a contract is signed, the first thing that happens is there's an inspection period. And so that inspection period is 10 to 14 days. And during that inspection period is when you're allowed to find out anything about the property that you want to know. So you can have an actual physical inspection with the home inspector. You can find out, what's the zoning, what school district is it in, what's the lot size. You can have the property surveyed. You can get a surveyor out there to actually measure the property if you want to. You can find out the history of the property. Anything you want to do, that's your time during that inspection and due diligence period to find out everything you want to know about the property. And during that inspection period, if there's anything you find out that you don't like about the property, something that's unsatisfactory that you didn't know before, you can legally use that as a reason to get out of the contract. So it doesn't matter what it is. It doesn't matter how major or how minor. You can just say, I found this thing. I don't like the property anymore. Let's call it off. And that's fine. And there's, really nothing that the seller can really object to, about that. Now, if you're on the seller side, if you're the seller and you're trying to get out of that contract, the buyer could request, certain repairs or remedies from things that they learned during that inspection period. And you could just refuse to do that. You're under no legal obligation to make any sort of repairs or remedy any things with the property for the buyer. You can just refuse. Now, on the other side, the buyer can just say, fine, we'll still take the property in the condition it's in or with these, apparent problems, and then you're still stuck. But, that's something that maybe could work. The second avenue, if you're financing the purchase of the property, in the Louisiana contract, you list out your financing conditions. So you say in the contract that this is going to be a finance sale, and these are the terms that I want to get. So you would say, 3.5% mortgage over 30 years, anything else, FHA loan, VA loan, whatever it is, you would specify all the various financing conditions in the contract to purchase the home. And that becomes part of the contract. So it says if you can't meet those financing conditions or get financing according to those conditions, then that is an opportunity for you to terminate the contract. Now you actually have to make a good faith effort to get that financing. So you can't just go to one lender, get rejected, and then that's it. You have to go to at least a couple lenders, to try to make it work. And you have to provide them with the documents that they ask for and all those kind of things. You have to actually cooperate and act in good faith to try to get financing. But if it really can't happen, you can say to the seller, I can't get financing. We need to terminate this contract. Now, the seller can say, under the contract, they have the option to provide that financing themselves. So they could come in and step in and be the lender and just say, I'll lend you the money, I'll mortgage the property, and I'll just hold the mortgage just like a bank would. And that is an option available to sellers. Not a lot of sellers will do that because if you don't have a paid for home, you have to pay off that mortgage on the property before it can be transferred. And so a lot of people just don't have that kind of cash laying around where they can pay off their mortgage and then owner finance a property. And it makes a lot of sellers just very uncomfortable in general. But that is an option they have. So the financing situation isn't always going to be 100% of the time get you out of a contract. Whereas finding something in the inspection period that can. The next one is going to be the appraisal. So if the sale is conditioned on an appraisal, which it doesn't have to be, but it is an option, you can make the sale conditioned on an appraisal. And usually if you're financing it, the lender is going to require that you make the agreement conditioned on an appraisal. And let's say that the property doesn't appraise for the price that, that was agreed to. So it appraises for less. You would have the option to get out of that contract, but the seller also has the option to just lower the price to that appraised price. So the seller can just say, we're going to lower it to the appraised price, and you're still stuck in that contract. But if the seller refused to do that and said, we're not going to lower it to the appraised price, but we'll lower it to $2,000 more than the appraised price, well, then the buyer can just refuse to accept that and say, no, we're going to terminate this agreement. So those are some of the kind of options there. And so those are the legal options that you would have within the contract. Now, there are some other more personal options of just ways that you could try to negotiate it and work it out. If you're a buyer or seller who wants to get out of the contract, you can just always just ask and just say, look, I made a mistake. I don't want to buy this property. Is there any way we can terminate the contract? And a lot of times, if too much time hasn't gone by where the property hasn't been, tied up and off the market for too long, a lot of times, that'll be fine. And everybody will just go about their business and, try to find a new person to buy the property, and it's no big deal. So that can sometimes work. But, if they really wanted to hold you to the contract, they could do that. And in the contract, the stipulations for you defaulting on that contract, if you just said, I'm not doing it, I'm not selling this property, or I'm not buying this property, then, the damages are pretty high. So in the contract, well, you can always just terminate the contract. But the other option is you can demand specific performance, which is the court would actually force, the defaulting party, buyer or seller, to either buy or sell that property. Now, on the buyer's side, that's a little more difficult because, a court can't make money appear. So, a judge can order that you buy this property, but if there's no money, there's no money. But on the seller side, it happens frequently, where a seller can be forced to sell a property because they're not, having to come up with any money in that situation. So, there have been situations that I've seen where a court will order, you agreed to sell this property to this person. They've met all their end of the bargain. They have their financing. They're ready to go. So you're selling it to them. And so that can happen. If they don't want to go that route, they can also ask for 10% of the purchase price as stipulated damages. So, and that's, that can be a pretty hefty sum depending on what the agreed purchase price is. If you're talking a $250,000 house, 10% of that is a pretty huge hit. So depending on who the defaulting party is, the other party could demand that from you as stipulated damages. Now, of course, it always is advantageous in these situations to work it out more amicably than that, because in these situations it would put this property as the subject of litigation. And as soon as that happens, there are things you can file to cloud the title of that property, meaning that if they, try to transfer that property to somebody else, when the title attorney like me is doing the title search, it would pop up in there that there's litigation surrounding this house. And so you can't transfer it to anybody because, it could, who knows how the court case is going to work out. And so that can tie up a property for, best case scenario would be probably a year. If it actually, was thrown into an actual lawsuit and there was litigation. And if there's litigation, it could take up to 3, or more years because, litigation just takes a long time. That's just the way it is. So it always is better to try, if you can, to work something out that, that everybody can live with, rather than, starting some big legal battle over, enforcing this contract. So, and generally you don't want to have to force somebody to, to buy your house, or you don't want to be forced to sell your house. That generally just kind of creates a sticky situation that, that nobody really wants. Like generally you want everybody to be happy in the situations because somebody's buying a house and somebody's, selling their house, but it can and does happen. But, those are the options that you have if you were going to get out of the contract. So, to reiterate, the best one is just during that inspection period. If you decide it was a mistake, the easiest time to get out of the contract is just during that inspection period. Otherwise, you're just going to have to, hope that either there's a financing issue or an appraisal issue or something like that, which is, still taking a risk because that may not happen. So really the inspection period, getting out of it during that time period is really the only kind of foolproof way to get out of the Louisiana purchase agreement. So you should really, be thinking hard before you sign a purchase agreement, whether you really want to buy the property and, if you're the seller, you should really be thinking before you put your property on the market, you really should be sure that you want to sell it. But if you're a buyer, really be sure before you sign that purchase agreement that this is really the property you want. But if for some reason you've signed a purchase agreement and then you wake up the next day and it's not right, use that inspection period. So that inspection period is your time to really think about it and find out everything you can about that property to get out of it. That's what it's there for. Otherwise you could very well be stuck, with that contract, and you'd have to, abide by it or possibly, get sued in court, and nobody wants to see that. So I hope y'all enjoyed that episode. I know it was kind of a short one, but there are just not a lot of ways to get out of a real estate contract because it is a serious obligation. It's a contract that you sign. So that's why it was kind of a short episode. If you're watching this on YouTube, please like the video and subscribe to the channel so you can keep up with all the new episodes that come out. If you're listening to this on a podcast platform, please give us a good rating. Tell your friends about it. Follow us on social media. We're going to put the social media links down below. And otherwise, we'll see y'all next time. Thanks for listening.